Okay, I have 11 o'clock, and I wanted to introduce myself. I'm Suzanne Collins. I'm the Communications Director at NFIB Pennsylvania, and don't forget that all of you can call me at any time for any assistance you need with your small business. And I'll give you that number, which is 717-232-8582. I want to thank you for joining our webinar, and you know the topic is the employee versus the independent contractor dilemma. It's something a lot of people are very concerned about now, and we're lucky to have with us an expert presenter. She's Senior Executive Legal Counsel at NFIB's Legal Center, Elizabeth Melito. I call her Beth. And during this webinar, if you have any questions at all, we will answer them. So just type them in on your screen. I'll be monitoring it, and I'll make sure Beth gets to your question. If it gets very difficult, we can always email you back and address your question at the end if there are too many. Okay, Beth, we're dying to hear what you have to say about this difficult situation for small employers.
Well, thank you so much for inviting me to present, and thank you all for taking time out of your day to listen. I have my contact information on the very last slide, which you'll see, but I would just want to say at the outset that if for some reason you have to hop off, something comes up, Suzanne and I understand that completely, and the good news is that the webinar will be archived and will be available for your viewing pleasure later on too. So if for some reason you get cut short today, know that. Also, my contact information is available on the last slide. So if you have questions you want to talk to me on the phone or email me about later on, whether it's regarding this or just some other general HR matter, please know that I'm available as a resource. That's part of my job here at the NFIB Legal Center, is to provide information and compliance assistance to NFIB members. I take calls from and emails too from members every day, and I'm very happy to do so. So the independent contractor versus employee dilemma. This has been coming up more and more, and I hear about it from members, and I told Suzanne before we started, I said I actually have a couple good stories, won't use names, but real NFIB member stories that have come up just within the last week regarding this very issue. And you hear about it more and more. I think both the federal and the state regulators are looking at this more closely. And I think it's coming about really because of the slow economy and the pullout of the recession. Using independent contractors, it's more and more common, and for very good reason too. Independent contractors can certainly be used to reduce the amount of money that business owners have to spend on things like health benefits, insurance premiums, unemployment, workers' comp, overtime, all those sort of things. But employers do need to make sure that they correctly classify independent contractors, because as I will talk about today, misclassification can cost you a lot more than you're saving. And that has been felt from one of the members I spoke with last week too. It can be a very expensive mistake. The slow economy is part of the reason why government agencies have been giving this misclassification issue more scrutiny. I mean, in short, it's about, in somewhat, not just worker rights or protecting workers and ensuring that there's workers' comp coverage and unemployment coverage, but really it's about raising revenue, because the revenue authorities, federal and state, are concerned that in some instances maybe somebody who is classified as an independent contractor may not be paying all they are supposed to when it comes to taxes, those W-9 folks. So let's real quick definition here. I should say too at the outset that in Pennsylvania, as in most states, really the presumption is almost that somebody who receives remuneration, in other words, anyone who is paid for work, is an employee. So if you're paying somebody to do a job or do some work, the presumption is that they're an employee. So the onerous, the burden, if you will, is on the business owner to show that no, in fact, this is really an independent contractor. So this is a self-employed person or business, because independent contractors can also be a business too. They can be their own corporation. And they are in fact not employees. And title and contract alone, label and contract alone, do not make somebody an independent contractor. So that's very important. You give them the label, you can execute a contract if they are in fact an independent contractor. But just calling somebody an independent contractor or paying them through a W-9 does not make them an independent contractor. An employee, again, is very broadly defined, and in Pennsylvania, as in a lot of states, the presumption, again, is if somebody is being paid for work, they are an employee, and then the burden is on the business to demonstrate, no, this was actually, I was engaging an independent contractor. They are not an employee. I did not need to have them on payroll. So 1099 abuse, as I said, this is getting a lot more, the misclassification issue is getting a lot more attention and scrutiny from a lot of different people, a lot of different government agencies at all levels. You probably maybe have saw the news coming out of California that a court in California just found that Uber drivers in the state of California are employees, not independent contractors. I mean, that could be a game changer for the company unless they do some things to alter their, business structure, if you will. FedEx Ground, not FedEx Air, but FedEx Ground, that's the purple and green trucks. They have been an ongoing dispute for, gosh, probably 10 to 15 years over whether or not they're ground. They currently, in many states, classify them as independent contractors. Microsoft, when I first started at NFIB, Microsoft just entered into a big settlement with a group of workers who had been classified as independent contractors. And interestingly enough, in that instance, the workers sued over their classification, or they alleged their misclassification. They weren't really looking for back wages or benefits or anything like that. They were looking for stock options with Microsoft because the employees got stock options. Independent contractors obviously did not. Then Shift and Instacart, two other gig companies that have also been hit with independent contractor misclassification lawsuits. And I just want to share with you too, well, I'll get here, let me first run through again, who cares? So the IRS, obviously I said it's about getting more revenue, more taxes. HHS, the Medicare, the Medicaid, Medicare in particular, payroll taxes, it's just easier to collect if an employer is taking it out as opposed to having somebody pay on their own. Department of Labor is concerned about individuals who are misclassified and should be classified as employees and are therefore entitled to overtime. And unpaid overtime, again, misclassification can be an expensive mistake with all these agencies, because there are penalties associated with misclassification. So it's not just a matter of paying back taxes or paying overtime, it's a matter of paying overtime going back 3 years. That's how far back you can go with unpaid wages. In Pennsylvania, the State Revenue Authority very concerned about the so-called tax gap. In other words, the difference between what is earned and what is paid, what is due the Revenue Authority versus what is actually paid. And a significant portion of that is alleged to be due to the tax gap, alleged to be due to misclassified workers. And Pennsylvania L&I, state agency that oversees unemployment, workers' comp, and then the health and safety issues, OSHA issues. So agencies in Pennsylvania that are also concerned about misclassification. And then finally, attorneys, because there is money to be made representing individuals who claim to be misclassified as independent contractors. And I went in, when preparing for the webinar today too, I was just Googling around, and I did find several attorney ads, attorneys in Pennsylvania, that focus on misclassification. And one of them has a Q&A on his website there, and he states there, many people who have contracts that say they're independent contractors are not independent contractors. And then he, labels do not control. And the mere fact that you sign an agreement meaning you're an independent contractor does not automatically mean that you're an independent contractor. And then he goes on to discuss all the things that you might be entitled to, including unemployment benefits, workers' compensation, family leave, disability pay, vacation leave, sick leave, overtime, and protection under state and federal anti-discrimination statutes. And he is very happy to represent you and help you assert your rights as an employee under all those statutes there. So you want to be careful because, again, not only will, I'm going to flip back here, not only will you be paying back taxes and maybe unpaid overtime, you're also going to be paying probably your attorney to defend your business and also the claimant's attorney, the misclassified worker's attorney too. So legal fees, as we all know, are very expensive. So you want to avoid all this. What's being done on this so-called misclassification issue? Well, the Department of Labor has invested a lot of money on hiring additional investigators to go out and really do targeted investigations, particularly in some industries. Construction is an industry that has been targeted, and also in Pennsylvania too. There was a special law passed in 2010 that I'm going to talk about there. Construction is an industry where there is alleged to be a lot of misclassification going on there. So DOL is putting money where its mouth is, if you will. And then the Wage and Hour Division at the Department of Labor just this past summer issued new guidance on independent contractors for its field investigators in the Wage and Hour Division. So they're the ones that investigate unpaid overtime, and also with regards to their health and safety inspectors too. And the memo says point blank, most workers are employees under the Fair Labor Standard Act's broad definitions. And the Fair Labor Standard Act is a federal wage and hour law that requires overtime for time and a half for all hours worked over 40. So as in Pennsylvania, the same is true with the federal laws too. Individuals, workers who receive remuneration, in other words, are paid for work, are presumed to be employees. And the ball then is back in your court, the business owner's court, to demonstrate and show that no, they are in fact bona fide independent contractor. So this is the Pennsylvania Construction Workplace Misclassification Act. There are 3 prongs to demonstrate that an individual is an independent contractor in this industry. And there are, again, stiff penalties for violating the law. And I'm going to talk more about each of these tests, the contract, the control from direction, and then the last one, they're customarily engaged in an independently established trade or occupation or business. So 3 prongs in the construction industry. This last prong there, customarily engaged in an independently established trade, occupation, profession, or business. This comes up frequently when you have an independent contractor or a consultant, as I often hear, who is pretty much just getting income from your business. And I mentioned too, I had 2 recent stories from NFIB members. One was regarding an IT consultant that a business was using too, and the consultant was really just doing work for the NFIB member. The NFIB member did not have an IT business, but this individual he hired to do his IT work was not doing IT work for any other business, and did not have an independently established business. So pretty much the IT worker's income was just coming from the NFIB member. What happened? The NFIB member scaled back the contract with the consultant to the point where it was pretty much just a few hours a week. The consultant, the IT consultant, filed for unemployment in that state, and that triggered an audit and a determination that the IT consultant was in fact an employee. So you're looking then at paying, penalties associated with that too. And then the concern with the member was, is this going to trigger other audits? And maybe, maybe not. In some states, the agencies are good or bad, depending on how we want to put it, are good about communicating with each other. They have open lines of communication, I should say. So in other words, if a business undergoes an UI audit, unemployment audit for misclassification, it could also very well in that state trigger a workers' compensation audit. One of the things that I'm going to flip back here that has come about from the Department of Labor's budget is grants, that last bullet down there, grants to states to focus on misclassification. Virginia was just awarded about $500,000 to focus on misclassification. And what the grant requires is that the state agencies communicate with the federal Department of Labor. So if an audit occurs on a business in Virginia, UI audit or workers' compensation audit, they will now need to potentially report that business's name to the U.S. Department of Labor, and that could be very problematic too, because then you're talking about a potential wage and hour overtime audit there. So these are problems you want to avoid by ensuring that your workers are correctly classified there, because the state agencies talk to each other, and that they are now more often talking with the federal agencies. Okay, let me move on here to talk about the confusion. Well, first of all, there's no single test. There are several different tests. The IRS test, it's this 20-factor test. I have the factors listed on the next few slides there. But I'm going to skip to what I have kind of come up with, a simplified test that I think kind of cuts through and gets to the main questions, the three main questions that you want to ask. The IRS test really focuses on these three components, and I have them broken down there. The last one there, again, are the written contracts. Again, do not focus solely on labels or contracts. The label or contract should come about after you've done the other analysis, after you're assured that, yes, this is in fact the work that's being performed. They have their own independent business. They do not have, I'm not controlling them unduly. After you've gone through the other factors, then you come up with a written contract. That's just one kind of touchstone, if you will, but it's not controlling. Labels are not controlling. So let me skip ahead here too. Again, I mentioned too that in Pennsylvania for unemployment compensation, this is also the presumption for the Revenue Authority too. This is coming from L&I's website there, and they do have a website that walks you through the different factors and the different criteria, if you will, that you can use to consider. I have them broken down in the webinar slides here too. But again, the presumption is that every individual who performs services for which he or she is paid is an employee. That's the presumption. And that's for unemployment, but then it's true for the Revenue Authority too in Pennsylvania. Okay, so the basic tests. These are the kind of the touchstone, if you will, going through these. If you answer yes to any of these, then odds are the individual is an employee. So if you answer yes, the individual is likely an employee. Do you instruct or supervise the person while he or she is working? Or is it a situation where you have a bookkeeper who comes in and the individual can come in pretty much any time they want? Maybe they usually come in on Tuesday, but really they could come in any day of the week. You hand over your ledger, they go and sit at their own desk, they do your payroll, but really you are not directing or controlling them. In fact, you really know very little about how to do payroll. They are your payroll person or your bookkeeper person. So in that situation there, you would not be found to be instructing or supervising the person while he or she is working. The next question, can the worker quit or be fired at any time? So with regards to this, something I emphasize rather a lot with business owners is you want to preserve that employment at will relationship with your employees. In other words, they can quit at any time for any reason. You can terminate them, fire them, in other words, at any time for any reason. So you both the employee and the employer have the right to terminate the relationship at any time for any reason. Not so with an independent contractor or consultant, because generally with them, you have hired them for the performance of a specific job. In other words, I just hired somebody to patch a hole on my roof. I expect, because I gave him a healthy deposit, I expect that he's going to complete that project. He's not going to start it today and then quit. I'm going to try to get some of my deposit back. So generally, a consultant or an independent contractor is hired for the duration of a project. So if they quit, or if you can fire them, and I've heard business owners say this too, well, I'm going to fire that contractor. Well, then they're probably not a contractor, they're actually an employee.
Hey, Beth, I want to jump in with a question here.
Yeah.
Now, but are you finished with the 3 points of the basic test? If so, I'll throw you a question.
Yeah, sure, go ahead.
Okay, so this questioner says, what about a part-time person being used maybe once or twice a month doing filing, light office duties as far as labor laws and paying $10 an hour? Can you make a judgment based on that information?
It sounds to me like that worker is an employee in that situation there. They're coming in and boy, I would suspect, I say boy, but I would suspect, you are telling them what to file, where to put it, right? I mean, they may have some flexibility with their schedule, but you are instructing or supervising that person while he or she is at work. So I would say that, just based on what you told me, and it's hard, there may be something else, but based on what you told me there, Suzanne, that individual should be on payroll.
Okay, and I have one question myself that I think people would care to know. Now, this third test, is the work being performed a regular part of your business? If you do hire a payroll person, that's kind of a regular part of your business, so you'd be yes on that but no on the others.
Well, a regular part of your business. So the example I gave was coming from a daycare. So the regular part of the daycare's business is caring for children. It's not payroll. Does that make sense?
Yes.
Okay, so and the example I gave about the IT worker, that was a company that does marketing. So the IT person was, doing network support, not marketing. The company was marketing. So in that instance there, and this is where the frustration came in from the NFIB member who was found to have misclassified this IT worker. Under question 3, the answer was no, because it was not, the IT work was not a regular part of the business. The business was a marketing company that did marketing for all these other businesses. But where the NFIB member failed was under, really, once you probed a little bit more, was under question 1. Was the supervise while he or she is working. So under further probing there, that's where it was kind of a gray area, because this individual was coming in, was sitting in the office alongside other workers there. It was almost like it was an in-house IT person. And maybe if I flip to the next slide, what I call the deeper dive there, that might answer it a little bit more. Because only if you answer, no to all these questions can you then go on to kind of the next slides, because you still should go through the next questions too, just to ensure yourself that, gee, this is really a valid, a legitimate, if you will, independent contractor and not an employee. So here is the deeper dive. And the first question here is where that IT worker failed. He did not have a separate business. He was only doing work for the NFIB member. So for the first 3 questions, the NFIB member was kind of okay, although upon further probing, as I said, he did admit that he was instructing or supervising the worker a little bit more than he should have been. However, that question number 1 there, the worker did not have a separate business at all. He was just, at this point, all his income was coming from the NFIB member, the marketing company there. Does the individual have the required business licenses? This came up with another call I had recently with an NFIB member who owns a salon. She rents out, chairs to other stylists, and she said, I generally have absolutely no control over them. They set their own hours, they have their own customers, yada yada. Sounds good, because this does happen in that industry somewhat. But here's the thing, she was offering to pay for the business license, the cosmetology license in her state, for a new stylist who just really didn't have, the resources to pay for it. And I told her not to. I said, you're crossing the line there. So you got to have your own, she needs to have her own business license and also pay for it herself too, to maintain that, that independent contractor status there. And then I also walked through the other thing too, because I also said the other thing you need to make sure is, I understand if she's going to maybe use your shampoo at the sink there, but she should otherwise be bringing in all her own supplies there, her own scissors, hair dryer, that sort of thing, setting up her own station, in other words, the booth that the woman was going to be renting. I said she needs to be, outfitting that herself. You cannot be supplying that at all there. And again, that goes to the financial investment. So is the worker buying their own supplies, making a financial investment, doing work for other people? I mean, that is just so important, doing work for other people. Do you have employees who do the same kind of work, providing training or any other benefits? And here is a big red flag that gets the attention of the IRS, and I know this from talking with our tax counsel here at NFIB. So this happens, somebody retires from a company and you and he or she decide to bring them back on a consultant basis. So they're retired and now they're going to be a consultant. They're retired, or maybe they just want to, this comes up sometimes too, they just want to go part-time. don't want to, work as much. Maybe they had a kid, different stage of life. They just want to scale it back a bit. So they're not going to be an employee. You're going to bring them back as a consultant. But guess what? They're doing the exact same thing as they were when they were on payroll as an employee. That is a huge red flag, and very rarely is that going to hold up as an independent contractor situation. Now there are some, situations where you can make it out, and I will give an example here at NFIB. We had somebody here who for years served as the head of, communications, media department there, left to start his own consulting business, and continued to do a little bit of work for NFIB, writing editorials for our president, Dan Danner. Very small percentage of his income of his new company, because he was doing work for an incredible number of associations around town here, and had his own business license, his own web page. I mean, he, hired his own bookkeeper. So in that situation, it would be okay. But, again, a percentage of this gentleman's income, from his former employer, if you will, was such a small percentage of what he was making from his new business.
I have a similar question here from one of our attendees, if I could.
Sure.
This person has a photography business and brings in freelance photographers to help with larger shoots. Now, those photographers are doing other work for other companies, and they are their own photography company. Are they subcontractors?
I think in that situation, it sounds like it's more of an independent contractor relationship, particularly, again, going back to, does the worker have a separate business? I mean, the real, the touchstones there are, free from the controller direction over the performance of the services, and that's where it might be a little bit questionable.
Yeah, because you might say, hey, I need you to be in this role, and you are supervising them.
Exactly. But if you can establish that they are customarily engaged in an independently, established business, that would go a long way towards protecting the business, if you will.
So if they have their own web page, if they have licenses, this kind of thing.
They have their own camera equipment, and in fact, they bring their own equipment to your shoot, you know what I mean? That sort of thing. All those things would be looked at as factors under that, that second prong there, the engaged and independently established a business. Maybe they have their own liability insurance.
Certainly questions to ask when you're bringing them in.
Yeah, exactly. But if it's a situation where, Janice helps you out, on wedding shoots, because those are your bigger shoots, and it ends up being, 3 or 4 weekends a month, and Janice isn't doing any other, photography work for anybody else, Janice is really a part-time employee of your business.
Got it.
Good question. Really good question. It's tricky, and these are really fact-specific inquiries, which I know is infuriating for business owners. But I think, going back to these three, the basic tests there are really important. And again, if you answer, no to any of these, then you really need to, kind of stop and think. And because there are maybe ways that you can restructure your relationship too, or encourage the individual, hey, I'd really like to keep you on. I can't afford the payroll costs, whatever. Is there, what can we do about setting you up, with a more established business, getting your own business license, things like that. Okay, so we'll walk through then 3 scenarios real quick, because I know we're running up against the clock here, and I don't want to keep people too long today here. This is a really, clear one here. Bob advertises in a local paper. He buys his own brushes. He shows up. This is like the roofer I hired to come to fix the leak in my house, who's there now. When he's complete, he sends me when it's completed, he sends an invoice. He's an independent contractor. Painter John. He reports to the same company every day. The company provides John with the paintbrushes, ladders, and other materials to do the job. They set John's working hours. He works for the company full-time. He's an employee of the company. Okay, that's another kind of clear-cut example there. So what about Mark? This is the harder, and this is where I know a lot of situations fall for our members. So generally, he works for the same company, but evening shift, 3 to 4 hours. He also does work on the side in the local, advertises in the local newspaper to get day jobs. And he has some discretion on which of those, 3 to 4 days a week he wants to work. I'm going to work just, Tuesday, Wednesday, Thursday, or this week I want to work all 5 days because I need some extra hours, that sort of thing. He's worked for the company in this capacity for several years. This is the harder question, although I will say that under Pennsylvania law, and I think now under the Department of Labor's new interpretation, Mark is going to be found to be an employee. In Pennsylvania, definitely for workers' compensation. So in this, again, a lot of times comes up, I hear from members where it comes up that, Mark files for unemployment if his hours get cut back or if the company decides to stop, using him, and he, and the company says, well, no, he was just an independent contractor. We were paying him, W-9. We maybe didn't have a written contract, but he was just a W-9 because he had his own business on the side. But going through the analysis there, the company provided him with the supplies. Yes, he did have an independently established business, but if you really dive down there, how much was that income as compared to the income he was getting from the company? So again, I think nowadays Mark is going to be found to be an employee. This is a situation 10 or 15 years ago that, maybe a business could have gotten away with classifying somebody as an independent contractor. But I think now, to be on the safe side, Mark should be on payroll. Bring him in on payroll. Oh, so
I have a quick question for you,
sure.
if I may.
Yeah.
This person would like to know, what if you are hiring a subcontractor? Is that any different? You have a job, you need extra people to do some other kind of work. What are the variables that would make that person an employee versus not? It's not too dissimilar, is it?
No, it's not. No. And let me skip ahead because this is the employment agencies solve the problem, and I'll just real quickly, I'm going to answer that question. I'm going to flip through because I have a slide that answers that very well there.
Sure.
So the employment agencies, well, then what happens here is if you hire, so in other words, a temp employee, more and more often, just be aware that there could be joint liability. So the temp company is found to be an employer, and the NFIB member, small business, is also found to be an employer. So there's potential for joint liability. In other words, both entities are found to be the employer, if you will, for the temp employee. So just be careful about that. A well-written contract with a temp agency can go a long way towards protecting your company. So let me flip ahead here, the risks of misclassification. We've talked about that a lot here because this is going to the situation of hiring a subcontractor, because there are things that you can do, businesses can do to protect the company from, misclassification claims, particularly if you have a, good contract and things you can do. So here are some things that the characteristics, independent contractor versus an employee there. And I think with hiring a subcontractor, it's important that you do not exercise control. So in other words, you tell them, I'm hiring you to do the bathroom, to do the tile work in all the bathrooms of this house that we're building here. And you're not going to go in there and supervise. It's, I've hired you to do the job, the tile work, and the kitchen, the bath, whatever. I'm going to come in and inspect it and make sure it was done, to my standards or to the homeowner's standards, but by and large, I'm hiring you for your expertise in tiling. And I know that you, again, going back to that, I know that you have an independently established business. You brought in your own tile tools. If I tell you that you need to rip it out and redo it again because it was not up to the homeowner's standards, you are going to suffer the loss of that. You're going to be out the work that you put into that, or the, the extra tile you need to buy, so you realize a profit or suffer a loss. You have your own business license. You maintain your own insurance, and that's very important too. You have your own insurance. And you carry, if you have any employees that work for you, so in other words, as a subcontractor and employees, he's carrying workers' comp for those individuals.
So
that
it's
helps
good
them?
to get all this in writing in a contract, correct?
Yeah, exactly.
And so that might cost legal fees, right?
Right, it might cost legal fees. We have, NFIB has an independent contractor handbook that has a sample template, a sample independent contractor agreement that you can download from our website. It's free, the handbook and the contract's in the back there at www.nfib.com/legal.
Well, I wanted to say I am going to, I'm getting a request, are we going to have copies of the slides? Because a lot of what you have you need to, think about and review. So I am going to take this recording, put it online, and I'll send everyone who's on the line or even registered but didn't get on the details. And also I'll give them that link, Beth. We can get that and send it out.
Great. And people can also email me directly, and I can email them a copy of the handbook. But putting your agreement in writing is very important. And that just will spell out, too, things like, again, the label is not, the telltale sign, if you will, but it can spell out things like you agree to main workers' comp on your people, you are maintaining liability insurance, you have a business license, all these things that will ensure that this individual, the subcontractor, doesn't come back, or the subcontractor's employees don't come back against you and allege a misclassification. So those are all things that a company can spell out in an agreement with a subcontractor.
I have a quick question, and that is, you passed by the thing about joint employers, and I know some people may have to go, and I know you're trying to speed it up, but that is important, because if I were to want to hire a temporary secretary because my person left and I go to a temp firm, do I need to have an agreement with them? What's the test there? Is it just the same? I mean, that's a little different.
It is a little bit different. And one thing I will say that I am actually a proponent of using temp agencies. I think it can be a very good thing, because in those situations there is generally, if the individual does go to file for, say, unemployment, once you find you don't need the employee, the filing's all done, you finally are caught up on the filing in the office there. It's all done, your office looks great, you don't need the individual. So you can just send them back to the temp agency. The temp agency will place them somewhere else. If the temp agency is also done with them, the individual will probably file for unemployment, but the employer of record is going to be the temp agency, not you, because the temp agency was the one that would, had them on payroll, not you. So it can really benefit, and I'm not getting paid by any temp agencies there, but I'm just saying for purposes of a small business with handling situations where, your workload shifts, I get that. And it's a lot to take on somebody as an employee, even a part-time employee. I get that. I mean, I ran through the expenses associated with employment. But temp agencies can be a good way to go, rather than just saying, oh, I'm going to, just hire a contractor and just pay them, as a W-9 person.
Okay, and people can review these slides and get a bit more detail on that, or even call you if they have more questions about it.
Exactly.
We do have another question, and I'm going to go ahead and take it, because I believe if people have to get off, they will. This is from a company that uses an IT technician on a very regular basis, at least a few days every week, and that person takes direction totally from the IT manager as to what his daily work would be. But his employer is another company. Would there be joint liability?
In that situation, I think there could be joint liability. It would depend. I'm assuming also in that situation there's probably a contract in place.
So that would help.
That would help tremendously. That would help tremendously, because that is almost more akin to the situation where you're hiring almost a temp agency. So I'm assuming that the IT person, and forgive me if you said this too, is on the payroll of the other company there. So is an employee of the other company.
That's a factor too. Yep.
That would be a factor too. Absolutely. Mm-hmm.
But let me just throw out, if this person was their own sole proprietor and they worked most of the time for you, and you had the computer they worked with and they were under supervision, then it might look very different.
Then it would be an employment relationship. In all likelihood.
So those are the factors.
Yeah, that's exactly. That's the member situation that was the real life, the real life scenario that I had a couple weeks ago from a member.
Okay.
Yeah. So then, I mean, you really, it's such a fact-specific inquiry, which is why I think having the slides will help. As I said, L&I in Pennsylvania has a web page on this too, but I'm happy to take questions. You really want to make sure that you go through, you know, the analysis if there's anybody that is, you know, kind of a questionable situation there. Somebody who, again, you're pretty certain is not getting income from anywhere else, or they're doing the same thing really that your employees are doing, maybe just not as often, you know, maybe just 1 or 2 days a week there.
Yep.
Again, that's an employee. You know, they're a part-time employee, but they're an employee. They're not an independent contractor. And, you know, again, I think going back to, you know, business owners who I have talked to most often, this comes up in unemployment, because what happens is the individual, you know, you discontinue their services, and in their mind they're out of job, and they go to file for unemployment. And your response, well, gee, they were an independent contractor, I paid them with a W-9, is not going to fly with the state agency. It's just not.
Okay. Anything else we're missing here? And any other questions, folks? Type them in.
And again, I'm happy to take, yeah, I was going to say, I'm happy to take questions offline. This is my contact information there. Thank you, Suzanne, for sharing the link to the Independent Contractor Handbook. And I will also be happy to email it out to anybody. If you want to just email me directly at my email address there, I can email it out too.
Okay, and just to let everyone know, there is sort of a short delay before we get the recording, so hopefully by the end of today, early tomorrow, we'll have those slides up on our website with the audio. And as I said, you can both call Beth or you can call here. I'll give you the number really quickly. It's 717-232-8582, and you can call us about any issue, and we'll get you to the right expert. Okay, someone just said, thank you so much, great info, Beth, and I agree. Thanks so much, and we'll be back with more information. The next time we'll let you know about our next webinar, and Beth has a wealth of information, so I'm sure we'll be calling her back again on another topic. Thank you so much, Beth.
Thank you.
Okay, bye-bye, folks.